March 25, 1991. Dear Clarence, please extend my kind regards to your wife as well as to yourself. I still look back upon the wonderful fellowship that I enjoyed with you in the few days that I spent with you in the Hendersonville, NC area in 1989. I have come upon much new information since that time, which I will try to place in a format here so that your local attorney will understand the importance of the remedy provided for us in the present commercial system of law. The present commercial system of law has replaced the old and familiar common law upon which our nation was founded, and I will explain the legal thread which brought us from the status of sovereigns over government to the status of subjects under government through our use of negotiable instruments, Federal Reserve notes, to discharge our debts with limited liability instead of paying our debts at common law with gold or silver coin. The change in our system of law from public law to private commercial law was recognized by the Supreme Court of the United States in the Erie Railroad v. Tompkins case of 1938. After this case, in the same year, the procedures of law were officially blended with the procedures of equity. Prior to 1938, all U.S. Supreme Court decisions were based upon public law, namely that system of law that was controlled by constitutional limitations. Since 1938, all U.S. Supreme Court decisions are based upon what is termed public policy concerning commercial transactions made under the negotiable instruments law. This law is a branch of the international law merchant, which has now been codified into what is now known as the Uniform Commercial Code, or UCC. This system of law was made uniform throughout the 50 states through the cunning of the Congress of the United States. This United States had its origin in Article 1, Section 8, Clause 17 of the Constitution, as distinguished from the United States, which is the union of the 50 states. Through its cunning, Congress offered grants of negotiable paper, Federal Reserve notes, which were given to the 50 states of the Union for education, highways, health, and other purposes, thus binding all the states of the Union into a commercial agreement with the federal United States, as distinguished from the continental United States. Having accepted the benefits offered by the federal United States as the consideration of a commercial agreement between the federal United States and each of the corporate states, the corporate states were then obligated to obey the Congress of the federal United States and also to assume their portion of the equitable debts of the federal United States to the international banking houses for the credit which they loaned. The equitable paper each state received in the form of federal grants was predicated upon this credit. This system of negotiable paper, binding all corporate entities of government together in a vast system of commercial agreements, is what has altered our court system from one under the common law to a legislative Article 1 court or tribunal system of commercial law. Under this tribunal system of commercial law, those brought before it are held to the letter of every statute of government on the federal, state, county, or municipal levels, unless they have exercised the remedy provided for them within that system of commercial law. By means of this remedy, when forced to use a so-called benefit offered or available to them from government, they may reserve their former right, under the common law guarantee of same, not to be bound by any contract or commercial agreement that they did not enter knowingly, voluntarily, and intentionally. Now that you see exactly how corporate entities of state, county, and municipal governments got entangled with the legislative democracy created by Article 1, Section 8, Clause 17 of the Constitution, and called here the federal United States, to distinguish it from the continental United States, whose origin was in the Union of the Sovereign States. Also, you see that the same National Congress rules the continental United States pursuant to constitutional limits upon its authority, while it enjoys exclusive rule with no constitutional limitations as it legislates for the federal United States. With that knowledge, you ask this question: how did the free white preamble citizenry of the sovereign states lose their guaranteed unalienable rights, be forced to accept the equitable debt obligations of the federal United States, and become subject to that entity of government and divorced from their sovereign status in the republic, which we call here the continental United States, given that they do not reside work, or have income from any territory subject to the direct jurisdiction of the federal United States? That is the question that has troubled sincere patriotic Americans for many years. The answer follows. The answer is that your lack of knowledge concerning the cunning of the legal profession is the cause of that divorce. A knowledge of the truth concerning the legal thread that caught you in its net will restore your former status as a free, white, preamble citizen of the Republic. Not realizing that our national Congress works for two nations foreign to each other, and by legal cunning both are called the United States, one being the union of the sovereign states under the Constitution, which I have termed the continental United States, the other being a legislative democracy, having its origin in Article 1, Section 8, Clause 17 of the Constitution, which I have termed the federal United States. Few people, seeing some so-called law passed by Congress, ask themselves these questions. Which nation was Congress working for when it passed this or that so-called law? Does this particular law apply to the continental citizenry of the Republic, or does this particular law apply only to residents of the District of Columbia and other named enclaves or territories of the democracy called the federal United States? Since these questions are seldom asked by the uninformed citizenry of the Republic, it was an open invitation for cunning political leadership to seek more power and authority over the entire citizenry of the Republic through the medium of legalese. Congress deliberately failed in its duty to provide a medium of exchange for the citizenry of the Republic in harmony with its constitutional mandate, but it created an abundance of commercial credit money for the legislative democracy where it was not bound by constitutional limitations. Then, after having created an emergency situation and a tremendous depression in the Republic, Congress used its emergency authority to remove the remaining substance from the medium of exchange belonging to the Republic, and Congress made the negotiable instrument paper of the legislative democracy, the federal United States, a legal tender for the continental United States citizenry to use in the discharge of debts. At the same time, Congress granted the entire citizenry of the two nations the benefit of limited liability in the discharge of all debts, telling the citizenry that the gold and silver coins of the Republic were out of date and cumbersome, so they no longer needed to pay their debts in substance, but were now privileged to discharge debt with this more convenient currency, issued by the federal United States. So everyone was forced to go modern and to turn in their gold as a patriotic gesture. The entire news media complex went along with the scam and declared it to be a forward step for our democracy, no longer referring to America as a republic. From that point on, it was a falling light for the Republic of 1776 and a rising light for Franklin Roosevelt's New Deal democracy, which overcame the Depression, caused deliberately by a created shortage of real money, by an abundance of debt paper money, so-called, in the form of interest-bearing negotiable instrument paper called Federal Reserve notes, and other forms of paperwork credit instruments. Since all contracts, since Roosevelt's time, have the colorable consideration of Federal Reserve notes instead of a genuine consideration of silver or gold coin, all contracts are colorable contracts and not genuine contracts. So, a new colorable jurisdiction, called a statutory jurisdiction, had to be created to enforce them. Soon the term colorable contract was changed to the term commercial agreement to fit circumstances of the new statutory jurisdiction, which is legislative rather than judicial in nature, and which enforces commercial agreements upon implied consent rather than full knowledge, as is the case with the enforcement of contracts under the common law. All of our courts today sit as legislative tribunals, and the so-called statutes of legislative bodies being enforced in these legislative tribunals are not statutes passed by the legislative branch of our three-branch republic, but as commercial obligations to the federal United States for anyone in the federal United States or in the continental United States who has used the equitable currency of the federal United States and who has accepted the benefit or privilege of discharging his debts with the limited liability benefit offered to him by the federal United States, and who did not avail himself of the remedy within this commercial system of law, which remedy is today found in Book 1 of the Uniform Commercial Code, UCC, at Section 207. A rubber stamp which reads "Without prejudice UCC 1207" is sufficient, when used in conjunction with one's signature, to indicate to the magistrate of any of our present legislative tribunals, called courts, that the signer of the document has reserved his common law right not to be bound to the statute or commercial obligation of any commercial agreement, that he did not enter knowingly, voluntarily, and intentionally, as would be the case in any common law contract. And pursuant to UCC 1-103, the statute being enforced as a commercial obligation of a commercial agreement must now be construed in harmony with the old common law of America, where the tribunal or court must rule that the statute does not apply to the individual who was wise enough and informed enough to exercise the remedy provided in this new system of law. By means of this remedy, he may retain his former status in the Republic and fully enjoy his unalienable rights, guaranteed to him by the Constitution of the Republic, while those about him curse the darkness of commercial law government, lacking the truth needed to free themselves from a slave status under the federal United States, even while inhabiting territory foreign to its territorial venue. I trust your attorney friend will have some ideas as to where you are coming from when you have him read this. If he still refuses to handle your case, contact me, and I will try to help you handle the case in propria persona. I hope to visit you again sometime. Your brother in Christ, Howard Freeman.
1 1 2 3 5 8 13 21 34 55 and beyond. Growth emerges from silence, from nothingness, zero. A single step of breath, one echo of itself. One from this reflection, duality arises. Tension, creativity, and motion through the spiral of life, expanding. 5 harmony in complexity. 8 an ascent to the unknown. 13 higher truths unfolding. 21 limitless possibility. 34 unseen forces align. 55 the tale that can be told is not the eternal